I've been the fly on the wall for more than 2 decades of sectional title disputes. I've got the data, the rules, and the real-world solutions. You're watching at Scheme Savvy, sectional title simplified. Think you can park a third car in your complex's visitor bay, or remodel your garage into a bedroom and park on common driveways permanently? If you are a landlord, you might think your tenants' bad habits are not your problem. And if you are a trustee, you might think your hands are tied when space runs out. Think again. Complex parking is a massive battleground. Today, we break down Prescribed Conduct Rule 3, the legal trap of garage conversions, landlord liability, and the roadmap for trustees to build new bays legally. Welcome back to Scheme Savvy, where we make estate living simple. Let's start with the baseline law. Under Annexure 2 of the Sectional Title Schemes Management Act, Prescribed Conduct Rule 3 dictates a strict no for common property parking. Sub-Rule 1 states owners and occupiers must not park or leave a vehicle standing on common property. Driveways, lawns, and fire lanes are completely off limits. The only exceptions are parking bays legally registered to your section, exclusive use areas, or visitors' bays. Any other common property parking requires written trustee consent. Under Sub-Rule 2, this consent cannot be permanent. It must state a specific fixed time frame. Trustees cannot grant indefinite parking rights on shared land. This triggers the 2 biggest daily friction points. First, visitor bay abuse. Many residents use garages for storage and park daily cars in visitor bays. Residents are occupiers, not visitors. This blocks actual guests and violates municipal town planning bylaws, which mandate keeping visitor spots accessible. Second, the 3-car dilemma. If a resident has 3 cars but only 2 allocated carports or garages, the legal reality is brutal. You do not have an automatic right to bring that third vehicle into the complex. You must either arrange a private lease to rent an unused bay from a neighbor, or secure a formal lease agreement directly from the body corporate. To lease a common property bay to you, the body corporate must pass a 75% special resolution at a general meeting, and they are legally entitled to charge you a separate, market-related monthly rental fee. Next is the dangerous trend of unlawful garage conversions. To gain living space, owners drywall their garage, install sliding doors, and move their vehicles permanently onto common driveways. This is a massive legal trap. Landmark court rulings like Manure versus Bay Dunes Body Corporate prove that garages have a strict, structurally approved zoning purpose. You cannot alter section use if it burdens the common property. CSOS adjudicators consistently order owners to tear down these illegal renovations and restore the garage at their own expense. Landlords face severe exposure here too. Under Section 13, Subsection 1, Part F of the Act, an owner must ensure occupiers and tenants comply with all conduct rules. You cannot just hand over keys and walk away. If your tenant violates parking rules, the body corporate will issue all warnings, penalties, and fines directly to your owner account. 3 tenant infractions cause the most chaos. First, using common property as a mechanical workshop. Doing repairs or dismantling engines in carports is strictly banned. Oil leaks deface the paving and cause serious environmental hazards. Second, abandoning unroadworthy cars. Under PCR 3, rusted, broken, or unlicensed vehicles cannot sit in open bays. They must be enclosed or removed entirely. Finally, reckless driving. Complexes are pedestrian zones. Residents, tenants, and delivery bikers must obey speed limits. Reckless driving down shared pathways is a major legal nuisance. These vehicle restrictions apply to everything on wheels. Caravans, trailers, boats, golf carts, and bicycles all fall under PCR 3. Residents often assume an exclusive use carport can double as a storage yard for a trailer or jet ski. It cannot. Most certified scheme rules state carports may only house licensed, roadworthy motorized passenger vehicles. Parking an unmotorized trailer there is an immediate breach. Golf carts must stay on paved roads to avoid property damage under PCR 4. Even bicycles are restricted. Chaining a bike to staircase railings or leaving it in passages violates municipal fire codes. Shared pathways must remain completely unobstructed for emergencies. When residents break these rules, how can trustees enforce them legally? Many schemes use illegal tactics. Under CSOS practice directives, rules allowing the body corporate to tow vehicles are uncertified and illegal. Trustees cannot authorize towing without a court order. Doing so is unlawful spoliation. Wheel clamping is permitted, but only if it is explicitly written into CSOS certified conduct rules. Furthermore, trustees cannot add parking fines to a monthly levy statement. Prescribed Management Rule 25 forbids debiting a levy account with penalties without written consent. Fines must be invoiced completely separately. But trustees can take proactive steps. If your complex has available open common property, you can legally build more parking. First, check local town planning bylaws to ensure the extension complies with municipal density and stormwater regulations. Next, get the mandate. Under Prescribed Management Rule 29 subsection 2, creating new bays is a necessary improvement. Trustees must send a 30 days written notice to all owners detailing layout plans and construction costs. If an owner requests a meeting within those 30 days, a general meeting is mandatory. The project requires approval by a 75% special resolution of the owners present or represented. If these new bays will remain open communal parking, that special resolution is all you need. But if you intend to allocate them to specific units permanently, you are creating exclusive use areas. This requires a special resolution to amend your conduct rules, featuring a scaled layout plan and an allocation schedule. This amended rule can only be enforced once it is formally approved and registered by CSOS. What if a stubborn owner or tenant ignores all warnings, skips the trustee hearings, and refuses to pay the separate parking fines? The trustees deploy the legal pipeline. The body corporate files a formal dispute with CSOS. If mediation fails, a CSOS adjudicator issues a binding order for specific performance, compelling the resident to move the vehicle or strip the illegal garage conversion. Under Section 56 of the CSOS Act, this order has the exact weight of a court judgment. If ignored, the body corporate registers it at court, and the High Court Sheriff will physically arrive to attach and auction off the resident's personal belongings to settle the debt. All actual legal fees are recovered from the rule breaker on an attorney and client scale, turning a simple parking fine into a severe financial crisis. Sectional title living requires shared responsibility. A complex is not a public parking lot, a storage yard, or an unregulated workshop. Trustees must remain procedurally fair, landlords must control their tenants, and rule breakers must remember that ignoring the rules just makes them incredibly expensive. If this legal breakdown helped you, hit the like button, subscribe to Scheme Savvy, and leave your parking stories in the comments below. Until next time, stay savvy.